Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Well, anytime a lawsuit is filed, pro se, you can expect to give your deposition, in addition to taking depositions too, right? But you can definitely expect the defense to take your deposition. And in taking depositions, this applies to all counsel. There is a time limit. Now, there are some exceptions, and we're going to talk about that today. The 7-hour rule and the exceptions. You need to be ready. So let's get started. Federal Rules of Civil Procedure 30 governs the taking of depositions. Its subsection D1 states, unless otherwise stipulated or ordered by the court, a deposition is limited to 1 day of 7 hours. It continues, the court must allow additional time consistent with Rule 26B1 and 2. And that particular section addresses the scope and the limits, if needed to fairly examine the deponent. It's referring to extenuating circumstances. And we'll get into that later. So let's continue. Or if the deponent or the person who's giving their deposition, another person or any other circumstance impedes or delays the examination. These are what I call aggravating circumstances, and we're going to look at some examples. That's not good, even though the court will allow additional time. So, pro se, I submit that absent any extenuating or aggravating circumstances, opposing counsel or whoever is taking your deposition should be able to complete it within 7 hours or 1 day. So let's look at some extenuating circumstances that can cause a deposition to go longer than 7 hours and even spill over to the next day. One extenuating circumstance is where both the pro se and opposing counsel agree to take a deposition past the 7 hours. Now, pro se, you may want to stipulate that both parties adhere to the 7-hour rule. And if either party need more time, you'd either consent or file a motion to the court asking for that additional time. During the 26F conference, both you pro se and opposing counsel will discuss various items. And the big ticket item is the deposition. And that's where you make your stipulation. Because once you and opposing counsel address all matters, you're going to put this in writing. You're going to meet with the judge. A judge is going to have your proposed scheduling order, what you submitted to the judge. After the discussion, the parties will come to some conclusion. This is what we agree with, judge. So the judge is going to sign it. And remember, the scheduling order is critical. I get a lot of questions about what do I do next? Your scheduling order is what helps guide you through this process and keeps you on track. Taking breaks and a lunch may extend the deposition beyond 7 hours. Now, you do have a right, pro se, to take breaks and a lunch. And so does the opposing opposing counsel's client have a right to take breaks and their lunch. The point is, don't factor these times into the 7 hours. Now, of course, if at the end of the day, the deposition, the breaks, the lunch occurred within 7 hours, then everybody's good, right? And let me say this too, pro se. If you believe in good faith that opposing counsel is abusing this grace, you can call the judge on the spot. But let me suggest that even before you get to the depositions, learn the court's protocol regarding how to approach it. Okay? So let's look at some aggravating circumstances that can extend the deposition beyond 7 hours. And to help me demonstrate this, we're going to look at case law. In Morales versus Zondo Inc., a 2001 case, the plaintiff took the defendant's deposition. The plaintiff alleged that the defendant's attorney's conduct caused the deposition to extend twice as long as contemplated by the parties, and that as a result of defendant's conduct, the expense of the deposition was also extended and was not necessary. And here are 6 things that the plaintiff alleged defense attorneys did to cause this extension. 1, that defendant's attorney refused to allow plaintiff's attorney access to the office telephone to call the court regarding a dispute that emerged at the deposition. And remember, I said earlier, pro se, you have the right to stop that deposition in a situation where the circumstances are aggravating to call the court. 2, that defendant's attorney engaged in improper private conversations with Elizondo, that's the defendant, out of earshot of plaintiff's counsel. That doesn't happen during the deposition. If the attorney wants to have a private conversation with his client, or if the client wants to have a private conversation with the attorney, they can do it on the break or at lunch, but it doesn't happen during the deposition. 3, that defendant's attorney improperly coached the defendant in order to indicate how defendant should answer a question, or to encourage the defendant to state that he did not know the answer. 4, that defendant's attorney improperly directed the defendant not to answer certain questions. 5, that defendant's attorney engaged in colloquies concerning the matters on which the witness was being questioned, as well as certain irrelevant matters. And 6, that defendant's attorney interrupted the deposition in order to inspect extraneous exhibits, and then he reshuffled the exhibits to make it more difficult for plaintiff's counsel to refer to them. Aggravating circumstances that will get you in trouble. So this case demonstrates an attorney's conduct that is not tolerated by the courts, and it also shows what an attorney is permitted to do. So pro se, whether you are the deponent or you're taking the defendant's deposition or someone else's deposition, the rules are the same. So you see what can potentially happen at a deposition. And now you know how to conduct yourself. And you also know how the defense counsel is to conduct himself or herself. And remember this, whatever their conduct is, be the bigger person in the room. I'm Advocate Lucinda, and we will see you next time. Take care.